I'm Eric Eisenagel, and I'm presiding today here for the 5th District Court of Appeal. Joined with me on the panel is Judge Rand Wallace and our newest judge, Judge Wozniak. And we have one case on the docket here for 9 o'clock, 2073 Henderson versus Florida. And counsel for the appellant, if you want to tell me how much time you'd like in rebuttal, I'll try to help remind you.
Good morning, Your Honor. Cornelius Demps for the appellant, Mr. Henderson. I would like to reserve 5 minutes for rebuttal.
All right, counsel. And with that, whenever you're ready.
Yes, Your Honor. May it please the court, counsel. Again, Cornelius Demps for the appellant, Mr. Henderson. Your Honors, the prosecution railroaded Mr. Henderson during his trial, and his attorney laid him down on the tracks. For 3 independent and distinct reasons, we're asking for the court to reverse the post-conviction court's orders denying Mr. Henderson's 3850 motions. First, the court erred in summarily denying claim number 1 because there are not sufficient facts that would allow for the claim to be conclusively refuted by the record, and he should have had an evidentiary hearing on his first claim for relief. Number 2, the trial court erred when it denied his request for the appointment of counsel because the Graham factors were not followed, and controlling precedent of this jurisdiction does show that he is entitled to have an attorney appointed for him. And finally, on the third ground, this court, the post-conviction court erred in denying ground number 3 after a hearing because it didn't follow the proper factors as required by Loeffler or Alcorn. Regarding claim number 1, Your Honors, the trial court did err in summarily denying the claim against Mr. Henderson. Before I go any further, would the court like a brief recitation of the facts?
I don't think that's necessary, Mr. Demps.
Yes, Judge. Yes, Your Honor. In claim number 1, Mr. Henderson alleged that his trial counsel was ineffective for failing to file a motion to suppress in this case.
And Mr. Demps, that issue hinges entirely upon the transcript that we have, which is the introductory paragraph or introductory questions by law enforcement officers concerning the Miranda rights for Mr. Henderson. Is that correct?
Yes, Your Honor. Prior to this proceeding on the motion, we did also file a motion to supplement the record with the full jury trial transcript, so the court could have an opportunity to review all the statements on the record related to that suppression, but the court entered order.
So the question is, and the answer is to Mr. It says the question is, Todrick, you have the right to remain silent. Do you understand that? And then it was the statement, you have to answer me. Is that correct? That's
the argument that was written by Mr. Henderson below, Your Honor. Yes, in that claim.
Okay, and his answer was yes. And so he's taking the position that that meant that he had to answer all questions from law enforcement despite the existence of his rights under Miranda versus Arizona. Is that correct?
Yes, Your Honor.
Okay. But the trial court considered that question and the answer and determined that that was just basically explaining to Mr. Henderson that he needed to make sure that in response to these questions, and specifically detailing the rights he has under Miranda, he needed to answer whether or not he understood each of the rights that he has under Miranda. Is that correct?
That is correct, Your Honor. The issue that we're facing, however, is, in fact, the voluntariness of Mr. Henderson waiving those Miranda rights when he spoke with law enforcement. As the record shows, Mr. Henderson was obviously a 19-year-old child, essentially charged with attempted murder with a firearm. He's interrogated in the early hours of the morning. As the Miranda interview does show, he makes
just so before you finish, and I'll let you finish that, but just so I understand where you're going with this, are you essentially raising an argument that wasn't raised in the post-conviction court?
No, Your Honor. We are continuing on the motion of the arguments that was made by Mr. Henderson regarding whether or not he had to truly answer law enforcement when they asked him, you have to speak to me. We are now just supplementing that based on the arguments that he's made below.
All right, how do you connect? All right, connect the argument you're making now to the officer's statement that you have to answer me.
Well, Your Honor, the question of whether or not Mr. Henderson had to answer police when they told him, you have to answer me, does go back to Mr. Henderson's sophistication and understanding and appreciating what he was being asked when law enforcement told him, you have to answer me, and that he waved and said yes. But what we're arguing is that there's never been an inquiry made on the record regarding the sophistication, the mental capacities, the education level, and the ability to appreciate what Mr. Henderson was doing when he waived those Miranda rights. Our argument is that his trial counsel was ineffective for failing to file that motion to suppress, and that there had to be an inquiry then made on the record to determine whether or not Mr. Blanker, his attorney, did have a proper strategic decision in not filing the motion to suppress based on his review of the record. That didn't happen at the trial court level. At the trial court level, on the day of trial, the judge, I believe it was the Honorable Judge Tynan out of Orange County, simply asked, is there a good faith basis for a motion to suppress? His attorney says, no, there's not. That's all he says, and the court goes forward. Your Honor, this is a case with some serious facts. This young man is now facing life in prison on an attempted murder firearm case. There had to be more issues raised. There are not sufficient facts on the record for the post-conviction court to summarily deny claim number one.
Counsel, do you agree that no reasonable person would have interpreted that statement as, you must answer all of my questions for all time, everything that I ask you from now until eternity?
Well, Your Honor, I'm sorry. I thought you were saying
that's the question. Do you agree? I mean, do you agree that no reasonable person would have interpreted it that way?
I think that a reasonable person in the right mindset, if we would have known what their mental state was on the record, could have made the argument of, okay, I can go ahead and answer the questions here. That's not the issue we have with Mr. Henderson. I mean, he's a 19-year-old kid who has serious mental capacities. There's serious issues that are going on with him. And at a minimum, what he was entitled to under a 3850 motion was at a minimum to have a hearing on that issue. Now, once he has the issue, then a lot of the questions that we all have could have been fleshed out on the record. What were the strategies Mr. Blanker developed in not filing a motion to suppress, and what he decided not proceeding on that? But Your Honors, that's not what happened here.
So Mr. Demps,
the record where the sophistication of Mr. Henderson and the arguments that you just made, where in the record is that raised that we have now?
Well, Your Honor, in the issue that we have right now is that does go back to the motion that we filed earlier, which was the motion to supplement the record. When the post-conviction court attached its portions of the trial transcript to deny the claim, we did request to supplement the record with the remainder of those transcripts so the court would have the opportunity to review all the information that we have available now, Your Honor. But this is a case where the facts are very significant, not to mention, when it comes to Florida case law, we have cited the Divine case, which goes over a myriad of factors that must be considered in determining voluntariness of Miranda waiver, and whether or not it has been made. None of that has been made on the record. At a minimum, he is entitled to get at least a hearing on that one issue and allow the court to determine what.
So Mr. Demps, how is it that you talk about waiver of Miranda, but if what you're doing is saying that any response that the defendant has to the introductory questions about understanding your Miranda rights, if he's not required to answer that with a yes or a no, and how does there ever become a waiver of Miranda rights that's binding?
Well, Your Honor, in this case with Mr. Henderson, specifically the facts of this case, there's more issues that have to be gleaned out from the record. As far as the long-term implications of Miranda and implications of waiver, that's not the issue that we really have before this court, Your Honor. The issue before this court is when Mr. Henderson, a 19-year-old kid, was interviewed by law enforcement in custody in the early hours of the morning, was his waiver voluntary? That's the issue that we have. And that issue is an issue that has to be fleshed out at the post-conviction court level. There has to be a hearing.
So what other indications were there to law enforcement that Mr. Henderson was not capable of understanding his Miranda rights? I'm talking about outwardly, short of having to conduct some type of psychological examination of Mr. Henderson before they even gave him the description of his Miranda rights.
Well, Your Honor, if we look at the trial or the record on appeal, pages 122 to 135, that does capture Mr. Henderson's full interview with law enforcement, they don't have to be psychologists to figure out that this child essentially doesn't know what he's talking about. He's running his mouth. He's implicating himself to other crimes. He is making several disparaging comments about what the incident is going on. It is abundantly clear that he is not able to appreciate what is going on. He doesn't know what is going on. And when law enforcement is doing that level of interview, they may not know what's going on, but as a skilled trial attorney, as Mr. Blanker was, he should have known that a minimum motion to suppress should have been filed. The problem is what we have here is that the post-conviction court then suddenly denied this claim. And without us having the opportunity to review the record, we essentially are holding this 19-year-old kid, the statements that he made to be used. And Your Honor, excuse me, Your Honor, and if that hearing would have actually happened.
My last question on this point, your brief doesn't really identify exactly which statements you believe should have been suppressed. And so it sort of left the reader to wonder which statements specifically, and what tailored argument you'd make for each specific statement. And if it was all of the statements, are we supposed to assume that as the panel? Can you sort of shed some light on the specific statements that you contend should have been suppressed?
Yes, Your Honor. We contend that the statements that should have been suppressed really was the interview in its totality. Essentially, at the end of the interview, Mr. Henderson denies the allegations against him. The reason why he denied the allegation is one.
So even the denial should be suppressed?
Yes, Your Honor, and that's controlling case law that we cited in the brief. A denial of itself can still be suppressed because the interview itself has no probative value. It's solely prejudicial. It surely shows bad character of Mr. Henderson, and really no skilled prosecutor would have offered this in evidence because if the defendant denies the allegations, there's too much of a risk that's apparent. There's no suppression, not even motion to eliminate, not even a 403 argument to be made, Your Honor. And because of that, every statement he makes regarding his relationship with Ms. Padgett, or the crimes that he has committed, the reasons for his denial, any of that, all of that should have been suppressed from trial.
Were those statements introduced into evidence at the trial?
I'm sorry, Your Honor?
Were those statements used at the trial by the state?
Oh, yes, Your Honor. Yes, Your Honor. Yes, Your Honor. Regarding issue number 2, the denial of appointment of trial counsel, we're also arguing the court erred in denying his request for appointment.
Counsel, it seems like your argument here on issue number 2 is just that, look, we need this was a credibility contest and only a lawyer could do the investigative work necessary to tear down former counsel's credibility. Therefore, appointment of counsel was necessary. Is that boiling it down to its essence? Is that your argument?
Yes, Your Honor. And because of
counsel,
that,
wouldn't that apply to every single post-conviction evidentiary hearing?
No, Your Honor, it would not. And that's what the
tell us, give us some examples of evidentiary hearings on post-conviction where that wouldn't come into play.
Well, I don't think Graham would apply if the defendant was convicted of, a possession of controlled substance and there was an issue of a motion to suppress. I don't think it would apply in a felony level. If counsel
didn't file a motion to suppress, you don't think there would be credibility issues?
Well, there would be, Your Honor, but the problem here in this case is under the Graham factors, because of the adversarial nature of proceedings, it's essentially a defendant versus his attorney. He had a right to have an attorney, or not a right, but there should have been an attorney appointed for him. And that's based on the case law of even the Gordon case out of this jurisdiction.
But no, the question is still why, right? I mean, he's not entitled to counsel. It's not an automatic, right? So the question is, why in this case should he have received counsel? And it seems like your argument is because credibility was at issue. And I guess I just wonder, isn't at an evidentiary hearing and post-conviction, isn't credibility on some level always at issue?
Yeah, it is. Well, Your Honor, that is true. It is an issue, but it is a very unique situation here with Mr. Henderson. I mean, this is not a run-of-the-mill conviction. This is a life sentence on a murder case. The Gordon case makes it very clear, and the Williams case make it very clear that because Mr. Henderson is not a sophisticated person, there's never been even an inquiry to that level, he should have an attorney appointed to be able to give him a meaningful opportunity to cross-examine Mr. Blanker and to advise the court of Mr. Blanker's Florida bar grievance history, which no one was apparent and unaware of, not to mention that the court does rely on the fact that it knows Mr. Blanker has dealt with him in the past, and that because of that, it finds grounds that he would be a more credible witness.
How would the bar history issues have been admissible?
Your Honor, and our argument is that the the skilled trial attorney could have filed a motion for judicial notice or could have prepared a memorandum of law to advise the post-conviction court of that these issues are present. Not to mention, Your Honor, there could have been an inquiry to determine, whether or not the claims that have been made against Mr. Blanker that ultimately did result in him being suspension and admonishments for a
But
bar.
how would the suspension or reprimand or whatever it was, how would that have been admissible to, I guess, impeach the counsel? How would that have been admissible? It doesn't seem to fall under any of the rules of evidence.
Well, Your Honor, the rules of evidence, credibility of the witness is always at issue and never collateral. So when it comes down to whether Mr. Blanker was truthful regarding his veracity when it came to speaking and conveying the offer, or his veracity when it came to developing a trial strategy in this case, Your Honor, that evidence would have been admissible and the court could have been.
Being reprimanded, I mean, I don't know what he was reprimanded for, or whether he was
Right.
reprimanded, but if he was, how do we know that that went to truthfulness? And if it didn't go to truthfulness, would it have still been admissible?
Well, Your Honor, I think, Your Honor, that question proves the point. I mean, those are facts that should have been fleshed out with the appointment of counsel at trial. At this point, Your Honor, the full bar history of Mr. Blanker is relevant, so that needs to be considered. I'm at 4.5 minutes. If I could briefly just address issue number 3.
It's up to you, counsel. Yeah, it's up to you. Go ahead.
Yes, Your Honor. Yes, Your Honor. Regarding issue number 3, we also would ask for the court to find the court denied, improperly denied ground number 3 by not following the Alcorn analysis. The record here clearly shows that if Mr. Henderson had been properly advised that Tara Paget's presence at trial does mean that she still could have gone, the state can still prosecute, he would have liked to go ahead and
Did the
accept that.
post-conviction court make a factual finding that your client was properly advised?
Your Honor, they did make it a finding that he was advised, Your Honor. But the problem is that during that hearing, Mr. Henderson obviously makes a lot of disparaging comments. He has an outburst that is very clear on the presence of the record, Your Honor. That issue number 3 really goes back to issue number 2, which we raised before, which is that had he had a meaningful attorney appointed in this case, not only could the issues of Blanker been brought up, but also that trial counsel could have shown that Mr. Blanker did not properly advise him regarding Tara Paget's presence at trial to testify for the state.
So essentially, if he had had a lawyer, trial counsel would have testified differently?
Well, if he had a lawyer, he would have had opportunity to meaningfully cross-examine Mr. Blanker and flesh out those issues further.
Okay.
Okay.
All
And
right,
with that,
counsel,
thank you,
you
Your Honor.
want to save the rest of your time for rebuttal?
Yes, Your Honor. Yes, Your Honor.
All right. Counsel,
Good morning. My name is Allison Morris. I represent the state of Florida in this matter. I would ask the court to affirm the post-convictions court summary denial of point 1 and the denial after hearing on point 3. There's no questions by this court. I will rely on my answer brief.
well, counsel, what about the appointment of counsel? I mean, the Florida cases are pretty clear that in these situations where you have an evidentiary hearing, that most of the factors are, likely met. Why shouldn't he have gotten counsel in this case?
Well, the standard is whether counsel was required for a fair and thorough presentation of his claim. And this was an articulate guy. In Gordon, the trial court didn't even exercise its discretion. In this case, it did exercise its discretion. And it was a pretty straightforward hearing on just which side the trial court or the post-conviction court found more credible. So the trial court didn't abuse its discretion in finding that it was a pretty straightforward issue that was to be determined at the evidentiary hearing.
All right. Any other questions from the panel? Okay, counsel, thank you.
Thank you.
All right. Counsel, you have 3 minutes and 8 seconds for your rebuttal.
Yes, Your Honor. Again, Your Honor, we're asking for this court to reverse the summary denials. I think if you read, well, I don't think, if you actually read the or the transcript of Mr. Henderson's post-conviction hearing where he cross-examines Mr. Blanker, it's abundantly clear that he's not articulate. He didn't have a fair and thorough explanation. He ends up essentially cursing at the witness during the trial to a point where Judge Barber has to admonish Mr. Henderson. That's important because it goes specifically to the lack of sophistication and the lack of education of the defendants in the Gordon case, the lack of the defendant in the Williams case, where those courts, including the 5th District, found that counsel should have been appointed for that hearing to allow Mr. Henderson to have a brief opportunity to be heard. Your Honor, I think the record is very clear here. Mr. Henderson did not get represented by counsel in a meaningful way as contemplated by the Sixth Amendment of the United States. The post-conviction court erred in summarily denying his claims for relief, and we ask for this court to reverse on all grounds.
Counsel, just so I'm clear, is issue 3, does issue 3 hinge on you prevailing on issue 2? I mean, you seem to acknowledge it's connected to issue 2.
Yes, Your Honor. I believe the lack of counsel and the meaningful opportunity to cross-examine that witness are intertwined.
All right. Thank you, counsels. We
Thank you.
stand adjourned.
Thank you, Your Honor.